So it is 2 p.m. in Paris. It is time to start. Thank you all for being here. It is an absolute pleasure to welcome you. So you do not see me on the screen, but I'm Alexandre Sénéganique from the Secretariat, and I will be here just to start with a few housekeeping issues before we officially start the event. So first of all, information about the 2021 Congress is available on our website and will be shared via social media with our hashtag IRCL Pretoria 2021. You can, of course, send an email to the Secretariat if you want to get the latest information, in particular about registration. We will be very happy to send you some information on a regular basis in this regard. As I have just mentioned the Academy's website, I'm also very happy to inform you that the Academy is launching today a podcast called Café Comparative, the first podcast being available since earlier this morning. It features a book discussion with one of the General Rapporteurs you see on the screen, Professor Laurence Burgorgue-Larsen, and who will of course be speaking later today, as you've seen in the program. We will also launch the first issue of our open access publication, Jus Comparatum, later this month. It will be dealing with the use of comparative law methodology in international arbitration. And you may know it follows our very successful conference held last year in Paris. Lastly, I remind you that the working languages of the Academy are both French and English. Accordingly, you can ask your questions in the chat directly to us in both languages, and we will collect them for you to ask them to the speakers. Naturally, our panelists are also free to intervene in any of the two languages. Il ne me reste donc plus qu'à vous souhaiter une excellente conférence et j'ai le grand plaisir de passer la parole à la présidente de l'Académie, Madame la professeure Katharina Belewalki.
Merci beaucoup, Alexandre, pour votre introduction. Chers participants à notre pré-conférence de Pretoria, je vous salue très cordialement, de près et de loin. Ces jours-ci, la conférence thématique de l'Académie internationale de droit comparé devrait avoir lieu à Pretoria. Pour des raisons bien connues, nous avons reporté d'exactement un an cette réunion internationale de 3 jours d'experts en droit comparé. Dear participants, I greet you most cordially, near and far. In these days, the thematic conference of the International Academy of Comparative Law should have taken place in Pretoria. For well-known reasons, we have postponed this international 3-day meeting of comparative law experts for exactly 1 year. Today's 2-hour webinar is intended as a preparation for the actual conference. It will give us a brief insight into the interesting topics that will then be discussed in more detail. I'm positive that we get a good taste of what to expect. The worldwide meeting in virtual space is actually very simple. It depends on 3 things: a computer or phone with a working internet connection and the right choice of time, taking into account the different time zones. And then we can connect within seconds. Without the pandemic, we would most likely not have taken advantage of the opportunity to announce the actual conference in this way. Who knows if we will not use this kind of fast and direct communication even more. But that are dreams of the future. Now the music is playing here and now. Je voudrais remercier toutes les personnes impliquées, Monsieur Edwin Cameron, notre orateur principal éminent et bien connu, ainsi que nos 4 rapporteurs généraux pour leur volonté de nous donner un bref aperçu de leur sujet et de leur travail de droit comparé à ce jour. Enfin, je tiens à remercier Alexandre Sénéganique et Bruno Souza Rodriguez pour la parfaite organisation de cette pré-conférence. J'espère que nous n'aurons pas de problème avec notre connexion Internet. Alors, nous avons un programme complet et le temps de parole de chacun est très court. I therefore close my short welcome speech in the sincere hope that we will meet personally in Pretoria next year. I hand over for a short greeting to the Dean of the Law Faculty of the University of Pretoria, Professor Elsebie Schumann. Please, Elsebie, take the floor.
Thank you, Katerina, and thank you for the welcome from your side, from the Northern Hemisphere. We are sitting here in the Southern Hemisphere, and I would like to welcome everybody to this virtual pre-conference. So this is where you would have been if you had been able to come to South Africa. You will see the purple jacarandas in the background, as well as a part of our lovely campus. And so I do hope that this pre-conference will inspire you to come to South Africa next year, to Pretoria, to the Faculty of Law, that is the top-ranked law faculty on the continent of Africa. Thank you very much for everybody joining today. I hope that we will have a very stimulating discussion, and I do hope that you will join us next year here in Pretoria. Please have a look at what is available in South Africa on our website, what you can do while you are here for the conference. But of course, our prime objective is to do comparative law. And so I am very, very thankful for everybody joining us today. And thank you also, Alexandra, for organizing this pre-conference. I think that it is good in these times to come together and to talk about the things that we are passionate about. Every time I'm on a webinar and I connect to people all over the world, it again relieves the pressure of your own lockdown situation, and it makes you positive again. So thank you very much for this pre-conference, for the organizers, and for all the participants out there. I saw people joining from Mexico, from all over the world. It may be an odd hour where you are at the moment, but thanks to this virtual reality, we are able to join. So welcome everybody and enjoy. I'm going to hand over to Professor Diego Fernandez Arroyo to introduce Justice Cameron. Over to you, Diego.
Diego, I think your micro is not. Sorry.
No, thank you. Merci beaucoup, cher Salit, ça va?
C'est très bien, merci.
The fact that the general topic, I say, of our thematic congress is plurality and diversity of the law, together with the selection of Pretoria as a venue, has facilitated the finding of the most appropriate person to deliver the inaugural lecture of our pre-meeting today, but of course, of the main meeting next year, for which we expect to be able to be physically in South Africa. That person is Justice Edwin Cameron, to whom the Academy deeply thanks for accepting our invitation. He will address the topic of plurality and diversity in the notion of sexual rights. Of course, it is impossible to summarize here the rich, inspiring life of Edwin Cameron, but let me mention just a few facts. He has been a human rights lawyer during apartheid, who received the Nelson Mandela Award for Health and Human Rights 20 years ago. He has also been an activist who has fought for LGBTI equality and was a first critic of AIDS denialist policies. Equally important, he has been a judge of the South African Constitutional Court until last year. And finally, after retiring from the bench, Edwin Cameron was elected Chancellor of Stellenbosch University and appointed Judicial Inspector of Correctional Services. So personally, for me and institutionally for the Academy, it's a huge pleasure to introduce him for this inaugural speech. And thank you again, dear Edwin, for accepting to be here today. The floor is yours.
Colleagues, Diego, thank you for the warm introduction. Katerina, thank you for presiding. Elsebie, many thanks for welcoming our worldwide audience to South Africa. We warmly look forward to seeing you all in person next year. It seems unimaginable now, but if we cast our minds back to February, it was unimaginable that this conference would have been postponed. So let us proceed with the next 2 hours in good faith and good hope and good cheer. And it's a particular honor for me to be presenting an overview of my keynote. I was asked to do it in 10 minutes, and I propose to stick to that. It is 14:09. I promise you that by 14:19 I will be done. I start by saying that the work of the Academy is of signal importance. Comparative law has played a very important role in the development of LGBTI rights. And I make the point that these developments have not been a gift from the global north to the global south. The global south itself has taken an active part in promoting LGBTI equality. And I start with 2 dramatic and memorable developments which occurred within a month of each other. On the 31st of March 1994, the United Nations Human Rights Committee gave its first decision, and the first decision by any international tribunal, on sexual orientation. It concerned a young Tasmanian man called Nicholas Toonen. And the decision held that sexual orientation equality, I'm stating it a bit broadly, they determined that laws prohibiting consensual same-sex relations in private between adults invaded privacy within the terms of their reference of the United Nations Human Rights Commissions. That was a momentous development at the end of March 1994. 27 days later, something momentous happens in our beautiful country, and it is that the Constitution comes into effect. After nearly 350 years of white supremacism, white suppression, white authoritarianism, we have a democratic, inclusive, non-racial constitution which opens up a vista of inspiring rights aspirations. And perhaps the most astonishing part of the Bill of Rights in that new constitution are the 2 words in the Equality Clause: sexual orientation. Never before in the history of constitution making anywhere had those 2 words been enshrined in an Equality Clause. Well, let me interpose here to speak about the role of the law, because your academy is very concerned with that. It would be fair to say that for most of legal history, the role of the law has been to subordinate, to enforce uniformity, to keep women in their place, to keep queers in their place. And of course, that was most signally the role of the law under apartheid. Apartheid was a system that was not the most bloody system of oppression and injustice and human rights abuse on the African continent. There were other systems that took a greater toll in blood and human lives. But the cruelty of apartheid lay in its very use of the law to systematically denigrate, subordinate, and humiliate Black people in their own country. Now, if you suddenly think after Toonen and after the South African Constitution that sexual orientation becomes a human rights issue, why is it so difficult? Sex and intimacy. If I'm telling you that I'm a proudly gay man, I'm telling you something about my erotic disposition. It's a very intimate fact about myself. Sex roles, women. Women challenge patriarchy. The idea of 2 women together, the idea of 2 men together is offensive to the patriarchal role. And of course, in Africa, we have the particular problem of white colonialism, where it is alleged by homophobes that the idea of queer equality was imported by white people. Of course, it wasn't. There have been same-sex activities and same-sex people in Africa for many millennia. What was imported were the Victorian criminal prohibitions. The other reason why it is so difficult to conceive of sexual orientation equality is that we are generally not visible, whether we intersex or transgender or gay or lesbian. We have not chosen this. It's a matter of nature for me. Gay people describe it differently. For me, it's absolutely clear that from before my toddlerhood, there was something different about me, and that difference lay in my erotic disposition and my sexual orientation. Other misconceptions: queer people are predatory, it's contagious, you can learn it. The fact is that it's a natural variant across all societies, cultures, races, and groups. A small element of sexual diversity, between 5 and 9%, maybe 7% of people like left-handedness. If I look at the participants now, we are 81 participants. We'll probably find that 7%, which is probably 6 of the 81 listening to me now, are left-handed. Very much the same for queer people, people who are sexually diverse. I struggled with this, but more importantly, for our history, a young black man from a township near Johannesburg called Simon Tseko and Cordy struggled with this. He took part in an uprising against apartheid, and he was put on trial for his part in the uprising, on trial for treason and for murder in the Delmas treason trial. And he came out to his fellow trialists. He made it possible for us, the lawyers with ties and suits, later to argue to the constitutional negotiations in the early 1990s that there should be protection for sexual orientation. 26 years later, what have we achieved? Well, as a lawyer, I always say not very much. I served as a judge in my country for 25 years. I feel no self-congratulation, no self-satisfaction, no complacency. There's far too much to still achieve. But nevertheless, the historic inclusion of sexual orientation protection in South Africa did make a difference. We have become the first country outside North America, some countries in South America and Western Europe, where a majority of people, black and white, rural and urban, township and suburban, a majority of all South Africans, 50% plus, say that LGBTI people should be protected by the Constitution, even though 2/3 of them still say that gay activity is wrong. So it's a wonderful paradox where people who disapprove of homosexuality still accept that they should have equality protection. And for our listeners and viewers in the United States, may I please ask you to convey that to Justice Samuel Alito and to Justice Clarence Thomas, who just a few days ago issued us incendiary dissent in a gay case, in a queer case, which didn't show that kind of understanding. So let me look very briefly in my last 3 minutes, because I'm going to keep my promise, Diego. Are you the chair of this session? You can cut me off at 14:19. In Africa, 30 countries still prosecute LGBTI people. Not one of us in South Africa, and that's another reason not to be complacent or self-congratulatory. Not one of us is free, not one of us has dignity and security until every person on the African continent, North Africa, Central Africa, East Africa, West Africa, Southern Africa, Central and East Africa. There are still the majority of African countries still persecute, harass, arrest, intimidate, put on trial, and often murder queer people. It is punishable by death in 3 countries, Somalia, Sudan, and Mauritania. The stigma, harassment, shame, assaults, persecution, and arrests continue. But this is changing. I started off with Tunen, I started off with the South African Constitution, and I want to say that the first continent-wide African statement of equal importance to Tunen in 1994 occurred on the 22nd of May, 2014, when the African Commission of Human and People's Rights adopted Resolution 275, which condemned violence and other human rights violations against persons on the basis of real or imputed sexual orientation or gender identity. A momentous achievement, which was again achieved by queer activism. High Court of Kenya, High Court of Botswana have both required their governments to allow queer organizations to register, even though there are still prohibitions on queer conduct. Then a Botswana court last June gave a most wonderful decision. A 3-judge bench ruled on the 11th of June 29 in favor of decriminalizing homosexuality. It ruled them discriminatory and unconstitutional, and the judges said human dignity is harmed when minority groups are marginalized. And with that, Diego, I come to my last comments, which I'm hoping to get in before the turn from 219 to 220, which is to return to the role of the law, in which people like myself and Elsevier, as white South Africans, have a very humbling role. What is the role of the law in the United States of America, in Mexico, in Western Europe? Is it to enforce class privilege, to assist accumulation of wealth, to reinforce extraordinary inequality of the super wealthy elite? My view, and that view is enshrined in the South African Constitution, is that the role of the law is to foster social justice, to foster diversity. And we know in Africa, we've had a terrible lesson in why it's important to foster diversity for queer people, for women, for all minorities, for religious minorities. There's an inherent aspect to it, the aesthetic aspect, that it's just wonderful that we're not all the same, that there really are some queer people, that there really are left-handed people. There's the instrumental reason that we flourish better when the law respects and nurtures us. And the last reason is the catastrophic consequences of rejecting a diversity, of enforcing uniformity. We saw those in those very months when Tunen was decided, when the South African Constitution took effect in Rwanda, when over a period of 90 days, 800,000 people were murdered because they were seen as Tutsis or associated with Tutsis. So Diego, Katarina, colleagues, dear friends, this has been my privilege. I congratulate you. I look forward to doing this at greater length next year, in a year's time. And thank you for allowing me the privilege of opening this pre-conference.
Thank you very, very much. I think it's, all of us are really wishing to be in South Africa next year, at least to hear your complete speech. And I don't know if some of the panelists wishes at this very moment to comment or to put a question. This is a good moment to do it. If not, we can open the floor for our attendants.
Okay, so on behalf of the attendants, I have I have here 2 questions to present Justice Cameron. The first one is on the role of constitutional courts. So should constitutional courts play a counter-majoritarian role in the promotion and defense of the notion of plurality and diversity in sexual rights? And the second question relates to a point that was raised in your speech concerning the criminalization of homosexuality. I'm sorry. And the question reads as follows. So how can the criminalization of homosexuality be overturned in countries where this policy enjoys large support from society?
Thank you very much, Bruno, for relating those questions. The first is a question of legal practice and legal theory. And I believe that constitutional courts have to nurture and foster plurality and diversity. It goes to the very core objective of the judicial function. The judicial function is not an anti-democratic function, it's a nuancing of the democratic function. And it is to protect those who do not have democratic entitlements or democratic majorities. So I think it's of the very core function of constitutional courts to protect queer minorities, to protect religious minorities. The second question is a really fascinating question. It's a question about legal strategy. How do you go about where a large majority of people, for the reasons I've given, revulsion, patriarchy, lack of knowledge about sexual orientation, diversity, support the suppression of LGBTI people? And I think the first step here is one that we are taking in Africa right now, and it is visibility. When I tell the 84 participants that I'm a proudly queer man, I know most of you will be familiar with it. It won't be a surprise to you, but there might be some people who feel that. But in Africa, when a Kenyan woman or a Ugandan transgender man or woman, when a Cameroonian queer faggot, sissy, all the negative terms that we've been called over the centuries, when that person comes out, that is the first step to changing society, to changing the law, to bringing the cases. And the brave people in Kenya, Botswana, and elsewhere who brought the cases have taken those first steps of visibility. And I just want to add this, that when I speak about coming out, I don't necessarily speak like Harvey Milk spoke in 1978 in San Francisco. You don't have to make a public statement. When you tell your best friend that I'm lesbian or I'm transgender or I'm bisexual, you are taking the intensely political act of coming out. And to me, that is the very first step of activism, and it's the very first step of legal strategy. And that's why the life of Simon and Cordy, whom I spoke about earlier, has been so important. Thank you.
Thank you, Edwin. I have a question on the chat, and I remind all the attendants that they can use the chat. There is not other possibility to put question. The question is, you mentioned at the beginning of your speech that someone is asking for what was concretely the role of comparative law in South Africa change.
Well, it's a hard question to answer because we were pioneering. You'll remember that in 1986, in June 1986, the Supreme Court of the United States, by a majority of 5-4, ruled that the states could criminalize homosexual relations between adults in private. So just 4 years later, we were arguing before the constitutional negotiators at the end of apartheid to include sexual orientation equality in our Bill of Rights. So I wasn't aware of the tune-in process at the time it was happening, but it was happening in parallel with our negotiations. And for next year's paper, I will look up the precise process with which Nicholas Toonen took his case to the Human Rights Committee of the United Nations. So I'm giving a fumbling answer, Diego, because in fact, there wasn't any comparative law that went as far as we did when we sought to include sexual orientation in our constitution.
Thank you very much. If there is no further comments from the panelists, I will give the floor to Elsavi. I have a last question, and I think we go to these questions, and afterward I will give the floor to Elsavi to present the first panel. The question is the following, Edwin, do you consider tolerance of diversity to be part of South Africa's constitutional identity right now? And if so, what is the role of the Constitutional Court in articulating and shaping that constitutional identity?
The Constitutional Court has made it's done various remarkable things. I can now say that as no longer being a member of the court. One of the things the Constitutional Court has done has been social economic redistributive justice in housing, in land, in various aspects. The other important feature of its work has been moral citizenship, where you can say to a young black woman, whose uncle is trying to take her house when her father dies. And the uncle says, Black African customary law in Southern Africa entitles only male relatives to inherit. The Constitutional Court in the case of Bear said to these two young women, you too are entitled to inherit. We're going to adjust traditional Southern African customary law to allow you to inherit. So it conferred moral citizenship on people like me, queer people like me, on young Black women, on women who wanted to occupy traditional roles in African society. So that has been at the very heart and core of the Constitutional Court's work in South Africa.
Encore une fois, merci beaucoup, Justice Cameron. Je suis sûr que ça va être magnifique l'année prochaine à Pretoria. Je crois mes doigts que ce soit possible. Et je dois passer maintenant la parole à Elisabeth pour la présentation du premier panel. Elisabeth, go ahead, please.
Thank you very much, Diego. And thank you, Justice Cameron. That was inspiring, and I know that everybody will want to come next year to hear the full paper from you and to also pose more questions. Following on that, it is my very great pleasure to introduce the two General Rapporteurs for Pretoria on the topic Diversity and Plurality in the Law, the Human Rights Dimension. So our two rapporteurs are, first of all, Laurence Burgorgue-Larsen, who is a professor of law at the Sorbonne Law School, where she is the head of the master's program in human rights and the European Union. She has also just published a book on 3 regional human rights courts based in Europe, America and Africa, and I personally would be very interested to read that, especially the section on Africa. And then also I would like to introduce Krzysztof Wojtyczek, who is a professor of law at the Jagiellonian University in Krakow. He is also a judge of the European Court of Human Rights since 2012 and vice president of section since May 2019. Welcome to both of you, and I'm now going to give the floor to you. I don't know who is going to go first or how you are going to organize this, but the floor is yours, Laurence and Krzysztof.
Merci beaucoup, merci beaucoup. Merci encore pour cette organisation parfaite grâce à l'Institut, à Alexandre. On remercie vraiment l'invitation. Je tiens à souligner aussi que l'intervention de Justice Cameron a été extraordinaire et très, très inspirante. Donc, merci encore pour cette inspiration. Chers participants, le questionnaire que Krzysztof et moi avons élaboré a tenté d'appréhender les nombreux aspects impliqués par la thématique très large du pluralisme et de la diversité dans les droits humains. Alors, je vais vous rappeler en quelques mots les grandes lignes qui ont guidé notre questionnaire, sans bien sûr rentrer dans le détail de toutes les questions que nous avons posées aux rapporteurs, pour que vous ayez en tête les questions qui ont été posées et les quelques réflexions qu'à ce stade on peut vous transmettre. Alors, s'agissant de la notion de pluralité, nous avons considéré qu'elle évoquait différents aspects de la relation à l'autre. Elle évoque tout d'abord la pluralité des conceptions philosophiques, religieuses et morales concernant le monde, l'homme. Et puis, bien sûr, elle évoque aussi le pluralisme juridique susceptible d'exister au sein d'un État, à savoir la coexistence de plusieurs ordres juridiques, de plusieurs ordres normatifs. Et s'agissant de la notion de diversité, on a considéré qu'elle présupposait évidemment une multitude d'identités nationales, ethniques, culturelles, linguistiques, religieuses, sexuelles ou autres. Alors, c'est sur la base de ces 2 grands axes que les rapporteurs nationaux ont commencé à travailler. Et les quelques pistes de réflexion que nous allons vous transmettre sont évidemment provisoires sur la base des rapports que nous avons reçus et des autres que nous recevrons bientôt, bien évidemment. Alors, il est vraiment très intéressant de constater une chose, l'extraordinaire convergence formelle sur la forme libérale des régimes démocratiques des États que nous avons jusqu'à présent étudiés. Et partant, nous avons réalisé que l'on assiste en quelque sorte à ce que nous avons appelé un encadrement libéral du pluralisme et de la diversité dans le champ des droits humains. En dépit de cette acceptation globale des principes inhérents au libéralisme politique et à l'importance de l'état de droit, qui ont évidemment des conséquences majeures sur la conception des droits de l'homme, on a pu constater également l'importance du poids de l'histoire et de certains éléments d'ordre sociologique qui démontrent dans certains pays qu'en dépit de l'acceptation formelle du pluralisme et de la diversité, la réalité est parfois très éloignée des déclarations de principe que l'on peut trouver dans les constitutions ou dans la législation. Donc nous avons voulu mettre en évidence parfois ce hiatus entre les textes et la pratique. Alors je vais passer la parole maintenant à Krzysztof, qui va vous présenter l'encadrement libéral du pluralisme et de la diversité, qui est le premier axe de nos réflexions provisoires. Et je la reprendrai ensuite quand le moment sera venu de présenter les contraintes historiques et sociologiques sur l'appréhension du pluralisme qui tendent à démontrer qu'il y a encore, malheureusement, beaucoup de chemin à parcourir dans la réalité. Alors, cher Krzysztof, c'est à toi pour présenter le premier point.
Merci Laurence, good day. I wish to greet all the participants, and I would like to thank very warmly the Academy for the invitation to present a report on the topic of diversity and plurality in human rights. As mentioned by Laurence, I will present the first facet of our research, which is the legal framework, the legal framework for plurality and diversity. But I will start with a preliminary remark concerning the essential tension this legal framework has to address. This essential tension is the tension between cohesion, unity on one side, and plurality, diversity on the other side. It's not easy to manage diversity and plurality and to keep all the different groups with all their identities together. And we have a growing number of examples of states which dislocated because of this problem, former Soviet Union, Yugoslavia, Czechoslovakia, but also countries, states like Sudan, Ethiopia. There is also this essential tension between the claim to universality of human rights and diversity of cultures, and plurality and diversity are sometimes argued to introduce exceptions or to introduce limitations to the validity of human rights and to contest their universality. And this is the general context in which the framework for the management of diversity and plurality in a liberal state has to operate. And in our research, we have distinguished two subtopics in this field. There are certain fundamental structuring principles, objective law principles, and on the other hand, there is a growing number of subjective human rights in this respect. Concerning now the first subtopic, the question of the general structuring principles, we have distinguished two such principles, and these are the principles of equality and non-discrimination, and the principle of neutrality. Concerning equality and non-discrimination, when one reads the different reports and when one studies the question, one notices a quite growing similarity concerning the methodology of application of these principles, equality and non-discrimination. Basically, the pattern from one jurisdiction to another is quite similar. It's about identifying a class of persons who are in an analogous situation, those who are in a different situation, and then to say whether the distinction applying to this group of persons in an analogous situations are legitimate or not legitimate. So the basic patterns, the methodology, the judicial methodology, there is a growing convergence. At the same time, sometimes the outcomes under this similar methodology may be quite different and quite surprising. This variety of outcomes may be explained by the fact that the application of the principle of equality is always happens in a certain legal culture, in a certain social mindset, in a world of values, of common values. The score of common values may vary from one society to another, and this is something which guides the judicial decisions and the application of these two principles. So I would basically agree with the view expressed by my compatriot, Professor Sadurski, in his monograph on the question, giving desert its due, when he notices that the application of equality and discrimination as principles, as legal principles, always depends upon certain fundamental axiological choices. And these fundamental axiological choices may vary to country, from country to country, from jurisdiction to jurisdiction. And this is why similar formal methodologies may bring considerably different substantive outcomes. Now, concerning the second principle, a few remarks concerning neutrality. This is not a universally recognized principle. This is a principle which is, moreover, not often explicitly stated in legal texts. This is rather a judge-made law which exists in many jurisdictions. We had a very interesting report on the question coming from Germany, coming from Canada. This issue of neutrality is also addressed by the European Court of Human Rights. And here the question arises how to apply this principle, what's this exact meaning, because references to neutrality may have different connotations from one country to another. And in this context, I would like to notice that the very choice of a liberal state is not a neutral choice, and a liberal state should not be ashamed of stressing this. This is not a neutral choice. This is a choice between different possible models of state. But then the question arises, to which extent diversity and plurality may be invoked by those who may contest diversity and plurality. And from the perspective of the state, the question is, what are the limits, the acceptable limits of diversity and plurality, and what to do with those who oppose diversity and plurality, and what are the permissible tools to address this contestation of diversity and plurality which may occur. What are the criteria for setting limits for diversity and plurality, and to which extent a liberal neutral state is entitled in its policies to promote certain views and maybe to moderate the promotion of other views. We don't have clear answers to this, but this is one of the topics which would deserve consideration, and it would be very interesting to compare the criteria and the approaches from one state to another. Now, concerning rights which protect diversity and subjective rights which protect diversity and plurality, we may distinguish individual rights, rights basically oriented at protecting individual identities, And there is a growing number of such rights. Quite often, private life, protection of private life is invoked to get protection of individual identities, various diverse identities. And this is so, for instance, in the case law of the European Court of Human Rights, where Article 8, protecting private life, is invoked to protect individual identities. But we have a growing number of rights, and we see reports which stress, for instance, the right to freely identify with an ethnic minority. There is the right to opt out from the minority status if a member of minority wants to be put under the general regime. There is a growing trend to grant protection from hate speech and different types of discrimination. There is a growing tendency to grant the freedom of assimilation and to protect freedom from assimilation, from forced assimilation. Another important tool to protect diversity and plurality is freedom of conscience, the right to education, the right to, including the right to education in one's own language, and the right to learn in public schools in one's own minority language. And then there is a growing number of instruments at domestic or international level which grant some collective rights, which recognize communities as holders of rights and which grant specific rights to the community as such. And this may go so far as empowering the community in matters of political life, giving the community some special instruments for participation in public matters. And this will be the issue Laurence will deal in this second part of our presentation. I will just like to stress that this tendency to grant group rights, rights to communities, to treat them as subject of rights, it's not a universal one, and there are countries which still contest this idea that the community may be a right holder and an actor with certain subjective claims, opposable claims, that may be justiciable in courts, but this is another matter. I will start now and I will come later. Thank you.
Merci. Merci beaucoup, Krzysztof, pour la présentation de cette première partie. Donc, je vais terminer les quelques remarques d'ordre général que nous pouvons vous faire à ce stade pour mettre en évidence quelque chose que nous avons estimé vraiment très important, toutes les contraintes historiques et sociologiques qui pèsent sur l'appréhension pratique de du pluralisme et de la diversité. Le poids de l'histoire permet d'expliquer l'existence d'importantes différences dans l'existence ou non d'une pluralité d'ordre juridique au sein de la structure constitutionnelle des États, dans la vision globale de la démocratie ou encore dans l'importance du poids accordé à une religion spécifique. Alors, si cet élément, nous allons le voir, n'a rien de surprenant, ce qu'il est plus, en revanche, c'est de constater une chose, c'est qu'en dépit de l'adoption de constitutions aux valeurs libérales, en dépit de la valorisation de droits individuels et parfois collectifs, certains États sont toujours fortement attachés à ce qu'on nommerait globalement leurs us et coutumes. Et leurs us et coutumes, nous allons le voir, sont parfois en totale contradiction avec les valeurs portées par le libéralisme politique. Ce sont donc deux points ici que je vais rapidement présenter, tout à la fois le poids de l'histoire d'un côté et le poids des us et coutumes entendus au sens large de l'autre, pour démontrer quelque chose que nous pensons être important, pour démontrer l'importance de la contextualisation de l'analyse du pluralisme et de la diversité. Sans cette contextualisation d'ordre historique et sociologique, on passe à côté du réel, ce qui serait bien dommage. Alors, quelques mots sur le poids de l'histoire. À ce stade, provisoire toujours de nos lectures et de nos réflexions par rapport au rapport reçu, on a constaté que ce sont trois domaines qui sont directement affectés par l'importance du poids historique dans la constitution des structures étatiques et de leur rapport au pluralisme. Premier point, la vision de la démocratie. Deuxième point, les structures constitutionnelles des États. Et troisième point, la place accordée à une religion spécifique ainsi qu'à l'exercice concret de cette religion. Alors, quelques mots sur le poids de l'histoire dans la vision de la démocratie. Krzysztof le mentionnait à l'instant, la notion de démocratie militante a été déployée dans des pays qui ont souffert de régimes autoritaires extrêmement puissants. Et partant, ici, il y a d'importantes limites au pluralisme. Ces limites au pluralisme au nom de la démocratie militante se manifestent de plusieurs manières. Tantôt par l'existence de clauses qui empêchent la révision d'éléments clés de la constitution dite libérale, mais surtout également la capacité d'interdire toute association politique ou religieuse qui aurait pour objet affiché ou secret de détruire de l'intérieur les valeurs libérales. Donc ça, c'est très important. Alors, c'est très connu en Allemagne, mais à la lecture du rapport tchèque, nous nous sommes rendus également compte que cette approche était très forte en République tchèque, puisque l'article 23 de la Constitution institue un véritable droit de résistance à quelconque activité qui aurait pour objet d'attaquer délibérément l'ordre démocratique, je cite, l'ordre démocratique des droits de l'homme, l'ordre démocratique libéral des droits de l'homme. Donc cette approche, il est intéressant de le souligner, a été confirmée par la Cour constitutionnelle tchèque dans tout un contentieux qui a démarré à partir des années 2000. Donc voilà, la notion de démocratie militante est une limite au pluralisme qui aurait pour objet éventuellement de détruire la propre démocratie. L'autre élément de l'histoire important qui a une incidence sur notre sujet, c'est l'histoire et la structure constitutionnelle des États. Les exemples allemands et japonais à cet égard sont vraiment très intéressants. On sait que les Alliés, qui étaient tout puissants au sortir de la Deuxième Guerre mondiale, ont tenu la plume, pour ainsi dire, des constituants japonais quand ils ont élaboré la Constitution de 1947 et des constituants allemands s'agissant de la loi fondamentale allemande de 1949. Et en dépit de cette mise sous tutelle, en quelque sorte, du pouvoir constituant par les Alliés dans ces deux pays, qu'est-ce que l'on constate? On constate des options opposées. L'Allemagne a opté pour une structure fédérale, le Japon pour une structure unitaire. La première permet le pluralisme des ordres juridiques, avec l'existence de 16 Länder, chacun avec leur structure très développée, chacun avec des tribunaux constitutionnels, qui protègent les droits fondamentaux, d'ailleurs certains allant d'ailleurs plus loin que ce que prévoit la loi fondamentale de Bonn. Mais à l'inverse, le Japon, lui, prohibe expressément tout système de décentralisation poussé, et la structure unitaire de l'État japonais empêche, ce faisant, de reconnaître aux 3 ethnies qui vivent sur les îles japonaises une certaine autonomie. Et ces ethnies, qui ont longtemps été assimilées par la structure japonaise, ont pu voir le jour et être reconnues grâce à la pression du droit international, mais cela n'a pas entraîné de la part des autorités japonaises une reconnaissance de leur autonomie, notamment politique. Enfin, sur le troisième point, dans la place accordée à une religion spécifique et à l'exercice concret d'une religion, le rapport pakistanais a été très intéressant à cet égard. Il est intéressant dans la mesure où l'État du Pakistan est né d'une confrontation avec l'Inde hindouiste, qui plus est dans un contexte de décolonisation très tendu, très problématique. Et les premières réflexions constituantes démontrent très bien l'ambition des constituants du Pakistan, qui était de créer un État distinct de l'Inde afin de faire survivre l'islam et de préserver les droits et l'influence des musulmans dans le sous-continent indien. Donc on sait que des périodes très violentes suivirent après le mouvement, l'accession à l'indépendance, et aujourd'hui, la constitution en vigueur de 1973 place l'islam au centre de la construction politique du Pakistan en faisant la religion d'État, tout ceci étant, si vous voulez, la continuité historique des événements passés. L'exemple vietnamien met également en exergue très bien le deuxième élément, à savoir la manière dont un État totalement imprégné de l'idéologie communiste diffusée par Ho Chi Minh, a adopté en fait une loi qui met en quelque sorte à mal la protection pourtant garantie par la Constitution, la protection de certaines croyances, notamment religieuses. Et donc la Constitution est libérale, mais c'est la loi sur la religion et les croyances qui va imposer à son article 12 eh bien, une obligation d'enregistrement de toutes les activités liées avec les croyances religieuses et autres, ce qui laisse à penser qu'il y a un contrôle politique en la matière. Et puis je terminerai mon intervention en vous signalant l'importance du poids de ce que nous avons appelé les us et coutumes. Le poids des us et coutumes démontre qu'il existe des freins absolument considérables à l'effectivité de ce que Krzysztof a rappelé, l'égalité entre tous, entre les individus, entre les groupes, avec son corollaire, le principe de non-discrimination. Alors, nous devons dire que le rapport japonais de notre collègue japonais a été très instructif et notre collègue japonais démontre avec brio le décalage entre le libéralisme affiché de la Constitution mais la pratique. Et il démontre très bien que les femmes, les étrangers ou les Japonais d'ascendance étrangère sont au quotidien, malheureusement, discriminés. Et ce qui est sans doute très grave, c'est que le pouvoir judiciaire japonais ne joue pas le rôle dont on a parlé au début de cette conférence, c'est-à-dire le rôle de contre-pouvoir de protection des minorités. Donc le propre pouvoir judiciaire ne joue pas son rôle de contrepoids et dans un contexte en outre où le système pénal reste particulièrement archaïque. Le rapport du Pakistan mettait en exergue aussi cette tendance, c'est-à-dire au Pakistan, les non-musulmans, puisque l'islam est la religion d'État, les non-musulmans sont tout à la fois, un, stigmatisés, deux, discriminés, y compris par les propres législations du pays. En revanche, et à l'opposé du Japon, la différence ici, et c'est tout à fait remarquable, la Cour suprême du Pakistan entend bien jouer son rôle de protection des minorités et, dans le cadre de la matrice libérale, protège le droit des minorités au nom de l'égalité et de la non-discrimination. Donc, ceci est particulièrement intéressant et il fallait le relever. Alors, pour terminer notre intervention, je redonnerai la parole rapidement à Krzysztof qui, en quelques mots, va conclure nos propos.
Merci Laurence. En guise de conclusion, deux remarques. I will end with two remarks. We have asked our rapporteurs, national rapporteurs, the question whether they can see circulation of ideas and whether their own legal system were inspired by other legal system or whether their own legal system have inspired other legal systems. And it's very interesting to see 2 points. First, some rapporteurs acknowledge the inspiration of international human rights law, and this is an important vector of circulation of ideas. Ideas circulate because of the human rights treaty bodies. And for instance, the Japanese report points at this inspiration coming from the human rights treaty bodies. And secondly, most of the rapporteurs, almost of the rapporteurs, simply say that they do not see any inspiration from abroad and do not see any inspiration for other regimes. And this is a conclusion which is quite surprising and quite often contestable. If we take an idea like militant democracy, there is quite important scholarship which shows how certain German ideas and concrete provisions of the German Grundgesetz have been then implemented in other borrowed from in other states and implemented there. So it's a quite surprising outcome that many persons working at the domestic level in their field do not see the circulation of ideas, whereas other scholars who do a more global research show such a circulation. And I do not have a good explanation for this. Maybe it will merit further research. Thank you very much.
Thank you very much to Laurence and Krzysztof. And I can see that a lot of hard work has already been done in a very short period of time. And we will be looking forward to your full reports presented next year around this time in Pretoria. So we have about 5 minutes left in this session. And so first of all, I would like to ask the panelists if they have any questions that they want to pose to the rapporteurs. And after that, we will go to the audience there. There's already a number of questions there. So first, the panelists, any questions from here? Yes, Diego.
Rather than a question, there is a remark. I loved really the way of Krzysztof and Laurence to present the report. But maybe something to them to elaborate a little bit more is this idea that of la démocratie militante pointed out by Laurence. How they see or how they evaluate this imbalance between promotion of diversity or plurality and the fact that the state is really worried at the safeguard of democracy. How is the evaluation from a human rights point of view? We have seen just in this very week the case in Greece. No, that is a very current problem.
C'est un problème très délicat, très délicat. Beaucoup de cours constitutionnels, enfin beaucoup de jurisprudence constitutionnelle, pour ce que nous avons vu des rapports allemands et tchèques, les rapports allemands et tchèques mettent très bien en évidence le rôle majeur ici des cours pour trouver l'équilibre justement. Et que le contrôle sera toujours un contrôle évidemment in concreto, et tout le cœur du contrôle se trouvera sur le contrôle de proportionnalité. Hein? Et donc on ne peut pas à ce stade, c'est mon point de vue, mais peut-être Krzysztof aura un autre point de vue, présenter une approche générale. Ça dépend du contexte de chaque pays, de l'importance des idées destructrices qui sont promues soit par des partis politiques, soit par des organisations religieuses. Et est-ce que ces idées promues par ces organisations politiques ou religieuses pour détruire la démocratie sont explicites, radicales et engendrent la violence? Et donc, s'il y a au moins ces éléments, alors l'interdiction du parti politique ou de l'organisation religieuse sera actée et validée par les cours constitutionnels, et le contentieux de l'interdiction des partis politiques en Allemagne comme en République tchèque le démontre avec force. Mais la balance, elle sera toujours entre les mains du juge constitutionnel. Si Krzysztof, tu veux rajouter quelque chose?
Just to confirm that the implementation of this general common idea of militant democracy varies considerably from one country to another, and there is a very interesting comparative scholarship on the issues showing the differences. That being said, there are some universal standards. There are also certain European standards set forth by the European Court of Human Rights. And we have a quite extensive case law on the issue of militant democracy and possible restrictions on extremist movements. So the diversity of national solution goes in pair with certain universality of standards, the main one being the one mentioned, the main tool being the one mentioned by Laurence, which is proportionality, of course. I profit from this occasion to maybe address two issues raised in the questions. What are the characteristics of subjective claims of subjective rights? Well, the answer would be the following. If it's about the legal characteristic of characteristics, then of course the main characteristic is justiciability. A claim a right is something that is justiciable, so one can go to courts and to get a judgment on the issue. And the question of universal human rights, is this defined by general public law? Is it something else? I would say, well, it depends. If we speak about general public law, then we stick to general public international law. But if we look at the issue from the perspective of political philosophy, then there are no obstacles from having a much broader list of fundamental human rights, which does not coincide with what is recognized in general public international law. So I would say that the answer is system dependent. Is it within the system of general public international law, or is it a more broader perspective of political and legal philosophy? Thank you.
Thank you, Krzysztof. You've already addressed one of the questions from the chat, and maybe we have time for one more. Bruno, if you want to come in with one question from the floor, please.
Sure. So there's another question here, which reads as follows. So is comparative law useful beyond the innate economic, political, and social structures between developed and underdeveloped countries?
Je veux bien essayer de répondre. De toute façon, vu que nous sommes dans une association où le droit comparé est au cœur de nos réflexions, je dirais que oui, évidemment. Quand bien même il y aurait une différence entre pays développés et pays en voie de développement, il ne faudrait pas utiliser l'argument du sous-développement pour éviter la comparaison et l'inspiration d'autres systèmes qui proviendraient notamment de systèmes développés. Ça, c'est un premier point d'ordre général. Bien évidemment, la comparaison entre les pays développés et sous-développés mérite des nuances, parce qu'il y a des différences énormes en termes politiques et économiques. Et peut-être donc, dans ce deuxième cas de figure, la comparaison entre pays sous-développés pourrait être tout aussi utile, peut-être sinon plus. Mais il ne faudrait pas, comme un argument de principe, s'opposer à l'utilisation du droit comparé en provenance des pays sous-développés qui refuterait l'utilisation des droits en provenance des pays développés. Voilà ce que je peux dire à ce stade.
Yeah, if I may add just one very short point. Well, comparative law is an applied science. And if you look at this from the perspective, for instance, of the European Court of Human Rights, well, part of the work, part of the job of the court is to compare legal systems. It's necessary to compare the different international human rights regime, the inter-American, one-African, European ones, but also it's necessary to compare the national legal systems, with the universal or regional standards, and it's an absolutely necessary exercise also at the worldwide level within the UN institutions who want to set certain standards. They have to be first aware of what's the situation in the different countries and how far the standards can go as a matter of legitimacy. So comparative law is a very important tool for all treaty bodies and human rights courts in the different parts of the world.
Thank you very much. I think we've just about run out of time for this session. So it remains for me to thank Laurence and Krzysztof for their presentation, which was very, very sophisticated, theoretically speaking, and provoked a lot of interest, a lot of questions arising in the chat. So thank you very much. You've really stirred a lot of interest out there, and I would invite all those who still wanted to pose questions and talk to the rapporteurs to come to Pretoria next year, where you can do so in person. So thank you very much, Laurence and Krzysztof, for your contribution to this session. And now I believe it is over to Professor Burgorgue, Katerina.
Dear Katerina, I think you have to unmute the...
Yes, indeed.
Yes, sorry.
I'm now, you can hear me? Yes. So thank you. It's my pleasure to introduce the second topic and the two general rapporteurs. From a comparative perspective, family forms and family functions show much diversity and plurality. Next to human rights, we have chosen the field of family law. It perfectly fits into our general topic, and the two general rapporteurs come from different continents. They come from Argentina and from South Africa. Just before the beginning of this pre-conference, they have seen each other for the first time, only on screen, but they have been working closely together for almost 2 years. The first rapporteur is Aida Kemelmajer de Calucci. She's from Argentina. She's a judge at the Supreme Court of Mendoza. She's also a professor at the Faculty of Law of Mendoza and a member of the Scientific Council of the Institute of International Private Judicial Law and Enforcement Law in Paris. She's a very well-known scholar in the field of family law, not only in Argentina, but in the whole of South America and also in Europe. Jackie Heaton is a professor at the University of South Africa, which is located in Pretoria. She is the author of many important and well-known publications in the field of family law and the law of persons. And I'm looking forward now to your presentation. We have only 30 minutes, but next year we will have more time and more opportunities to see each other in Pretoria. The floor is yours, and I think Aida will start.
No.
No.
Jackie.
Oh, Jackie will start. Excuse me. Excuse me. Jackie, please take the floor.
Thank you very much. I'd like to thank you, Katerina, and also the International Academy for this opportunity. We're going to present a preliminary overview of selected issues on the plurality of parents. As you know, the overview will be based on the answers to the questionnaire on the topic diversity and plurality in the law, family forms and families functions. Our questionnaire had two main objectives. The first was to determine whether, and if so, how family law recognizes that a child can have multiple parents. In other words, we investigated multiplicity of parents. The second objective was to determine which functions of the family the law recognizes and favors, and whether the presence of children in the family makes a difference in this regard. As multicultural challenges in family law were the focus of the 20th Congress of the Academy, which took place in Fukuoka, Japan in 2018, we did not consider multiplicity or plurality of civil, cultural, indigenous, and religious unions. We focused solely on multiplicity of parenthood. 12, I'm happy to say, 12 national reports have been submitted so far, 9 in English and 3 in French. Unfortunately, I have to make a confession, I do not understand French, so I could not read the French reports. Aida did that. For this pre-conference event, we've decided to focus on only 3 issues. The first one is the recognition afforded to step-parents. Second one is open adoption, and the third is three-parent child. I'll start with the recognition of multiplicity of parenthood in the context of step-families, and Aida will discuss open adoption and three-parent children. By far, most of the jurisdictions reported on do not automatically confer responsibilities and rights on a step-parent, and therefore do not recognize more than 2 legal parents in the context of a step-family. If a step-parent wants to acquire full responsibilities and rights in respect of the stepchild, he or she must adopt the stepchild, and most of the jurisdictions permit step-parent adoptions. Once the adoption has been granted, the step-parent has exactly the same legal responsibilities and rights toward the child as the child's biological parent has. Usually, a step-parent adoption terminates the legal relationship of the child with the other parent. In other words, the parent who is not living with the step-parent. If a step-parent does not adopt a stepchild, the step-parent can acquire limited responsibilities and rights if the child's legal parent delegates them to the step-parent, or if the step-parent enters into an agreement with the child's parent. For example, Portuguese law allows a step-parent to exercise responsibilities and rights in respect of daily matters only. If the step-parent is living with the child's parent in a de facto union, and that parent delegates the responsibilities and rights to the step-parent. In South Africa, the child's parent may confer any or all parental responsibilities and rights on the step-parent by way of agreement. But the parent who does so does not lose his or her own parental responsibilities and rights. And of course, in all jurisdictions, a court can confer responsibilities and rights on the step-parent. Interestingly, some jurisdictions automatically impose a duty of support or a duty of maintenance, whatever it's called, on a step-parent, even if the step-parent does not adopt the stepchild. In Quebec, for example, the in loco parentis doctrine can be used to compel a step-parent who acts as a parent to the child to support the stepchild even after divorcing the child's parent. And in South Africa, 2 court judgments have stated that a stepfather who was married to the child's mother can be held liable for the stepchild's maintenance. In Turkey, a step-parent also has a duty to contribute to a stepchild's maintenance, but this duty arises not out of step-parenthood per se, but out of the duty to contribute to family expenses. Some authors, Turkish authors, do, however, think that the Turkish Civil Code imposes a broader duty on parents and that extends to step-parents as well. In Estonia, a married step-parent has a duty to contribute to the maintenance of all family members, and this obviously includes the stepchild. Belgium has a similar duty. In Belgium, a duty to contribute to a stepchild's maintenance operates to the extent that spouses, in other words, married people, are legally obliged to contribute to the marital expenses and are jointly liable for debts for household necessaries and the education of children in the common household. In other words, children of either party in the common household. Therefore, a step-parent who is married to the child's parent indirectly fulfills a duty of support towards the child. A step-parent who is not married to the child's parent but lives with a parent in legal cohabitation must also contribute to the expenses relating to living together and is jointly liable for debts incurred for the purposes of living together and for the children the couple educates. And this duty applies even if the step-parent is not actually the person who is educating the children of either of the parties. It is important to note that the child support obligation is detached from parentage. As I said, it's not because of blood relationship or step-parenthood per se. It's because of the marriage or the legal cohabitation. De facto cohabitation is not sufficient. That does not entail any legal obligation to a partner's child. If a step-parent has incurred a duty of support and the stepchild's parent dies, the duty continues, and the step-parent must maintain and educate the child from the assets the step-parent inherited from the child's parent and from the benefits the step-parent received in terms of the marriage contract or cohabitation agreement or by donation. Turkish law imposes a further duty on step-parents. It obliges step-parents to show attention to and to care for their stepchildren who are still minors. The step-parent and the parent with whom the step-parent lives may set up house order rules which the child must follow. And in terms of Turkish law, each spouse must give the other reasonable support in exercising parental responsibility in respect of each other's children. They must also represent the other parent if the parent is unable to represent the child and the circumstances require representation. For example, if the child wants to enter into a commercial contract and the parent is not available, the step-parent must represent the child. If the relationship between the child's parent and step-parent ends, the step-parent may only in some jurisdictions have visitation rights or right to contact or personal relations, whatever it's called in a particular jurisdiction. Thus, in Belgium, the Civil Code entitles the step-parent to maintain contact with the child if the step-parent and the child have a particularly affectionate relationship and contact is not contrary to the best interests of the child. In Germany, the step-parent may ask for visitation rights if this will benefit the child. In Quebec, the in loco parentis doctrine, to which I've already referred, entitles the step-parent to claim contact with the child. The step-parent may even claim custody, but this will not confer parental authority and legal guardianship on the step-parent. It only entitles the step-parent to make routine decisions about the child's life. It's important to note that the in loco parentis doctrine applies only if the step-parent is married to the child's parent. An unmarried step-parent is in exactly the same position as any other third party. There's no preferential position. In Italy, a step-parent may obtain a right of contact if he or she has established a meaningful and lasting family relationship with the child and therefore is the child's social parent. So once again, it's not simply because he or she is a step-parent, the step-parent must qualify as a social parent. A social parent's legal position is less favorable than that of a grandparent and a grandparent's spouse or partner. Since 2013, the law has recognized a grandparent's right to have a relationship with his or her grandchildren. And in 2018, the Corte di Cassazione extended this right to a grandparent's spouse or partner, provided that the spouse or partner has shown himself or herself capable of establishing and maintaining a lasting emotional relationship with the child from which the child can benefit. Vietnam stands out as an exception to everything that I've said before, because Vietnamese law confers extensive responsibilities and rights on step-parents. In terms of the 2014 marriage and family law, a stepfather or stepmother is included as a family member and has responsibilities and rights in respect of the stepchild if the step-parent and stepchild live together. In other words, if they share a household, the step-parent automatically has responsibilities and rights in respect of the child. These responsibilities include the duty to look after and raise the stepchild and to protect the lawful rights and interests of the stepchild. The step-parent must also educate the stepchild. And interestingly, this includes guiding the stepchild in selecting a profession and respecting the child's right to select a profession and to participate in political, economic, cultural, and social activities. Further, a step-parent may not discriminate against the stepchild due to the child's gender or the marital status of the child's biological parents, nor may the step-parent abuse the stepchild's labor or incite or force the stepchild to act against the law or social ethics. Step-parents must furthermore create conditions for stepchildren to live in a happy and harmonious family environment, must set a good example for stepchildren in every respect, and must closely collaborate with schools, agencies, and organizations in educating stepchildren. In addition to the responsibilities described above, a step-parent who cares for and raises a stepchild as if the child was biologically related to the step-parent can inherit from the child, and vice versa. It is very important to note, however, that the responsibilities of step-parents are dependent on factual evidence of living with a stepchild. Furthermore, even if step-parents do live with stepchildren, they do not incur all the obligations that parents do. For instance, a step-parent does not have responsibilities and rights in respect of compensation for violations caused by a stepchild. Nor may a step-parent manage the stepchild's assets or dispose of the child's property Also, and this may be surprising to the audience in view of the extensive responsibilities and duties imposed by Vietnamese law, and also in relation to my earlier summary of the position in many other jurisdictions, it certainly was very surprising to me. The duty of support between a step-parent and a stepchild is not regulated by the law. And in fact, of the 2014 marriage and family law, the child's biological parents are the only ones who are obliged to support the child. The step-parent does not incur a financial duty of support, even though he or she incurs the extensive other duties. And now I'll hand over to Professor Kemelmajer.
Thank you very much, Kathy, for your previous work. It was really Kathy that prepared all this work. I only help us in some points. So as she said, I will take the two other subjects. Then I will speak in French. Okay, so let me see. Et donc, le premier point que je veux voir, c'est la reconnaissance de la multiplicité de la parentalité dans les cas d'adoption. Et donc, la première chose, c'est que quand on accepte l'adoption ouverte, c'est plus facile de trouver cette pluriparentalité. Donc, qu'est-ce que c'est l'adoption ouverte? C'est l'adoption où les familles, des enfants ont été adoptés, mais qui conservent des liens légaux ou de facto avec leur famille biologique. Donc, il y a des lois qui ne reconnaissent pas formellement l'adoption ouverte, mais par exemple, comme en Allemagne, on accepte que les agences d'adoption peuvent faciliter l'échange des informations ou bien des relations interpersonnelles avec la famille d'origine, qu'on peut dire. Il y a d'autres pays où les accords sont possibles, mais très rares dans la pratique, comme par exemple le Vietnam. Il y a d'autres pays où on accepte directement l'adoption simple, où il y a deux sortes d'adoption. L'adoption simple, et dans l'adoption simple, bien sûr, on conserve le lien. On ne rompt pas la relation parentale. Et donc, créer une multiplicité juridique potentielle entre les deux parents d'origine et les parents adoptifs. Ça, c'est le cas de la Belgique, c'est le cas de l'Italie, c'est aussi le cas d'Argentine, même si on n'a pas présenté encore le rapport argentin, mais je vous dis que c'est aussi la question en Argentine qu'on accepte les deux formes d'adoption. Il y a aussi ce qu'on appelle l'adoption d'intégration. Qu'est-ce que c'est ça? C'est l'adoption par les conjoints ou par le convivant du parent biologique. Et à l'adoption d'intégration, c'est possible aussi de trouver cette pluriparentalité si on conserve le lien avec la famille d'origine. En Afrique du Sud, l'adoption d'intégration n'est pas la même chose qu'une adoption simple, en Argentine non plus. Et donc, on peut trouver aussi cette pluriparentalité. Dans d'autres pays, comme par exemple Grèce, c'est possible que la personne adoptée peut conserver les liens avec sa famille biologique quand elle a été adoptée à l'âge adulte. Mais cette adoption qui permet d'être adoptée à l'âge adulte n'est possible qu'entre proches pour les sang ou par le mariage. Il y a des pays que, en respect de la culture d'origine, en général, refusent, on peut dire, l'adoption fermée parce qu'on veut conserver cette culture d'origine. Et surtout, c'est le rapport de l'Australie qui montre cette sorte de tendance de la législation. Et c'est pour cela qu'on encourage ou bien l'adoption ouverte dont je parlais au début, et aussi d'autres droits comme la connaissance des origines, l'information des données, etc. Il y a d'autres pays, comme par exemple la législation du Québec au Canada, qu'il y a aussi une reconnaissance des accords visant à faciliter l'échange des informations ou des relations interpersonnelles. C'est-à-dire, par exemple, ce qu'on appelait autrefois visite, qu'on appelle maintenant la communication, excusez-moi, oh là là, entre les parents adoptifs et les membres de la famille d'origine. Bon, il y a aussi des législations que bien qu'on ne reconnaît pas avec ce nom pluriparentalité, mais on donne des droits qui correspondent normalement aux parents. Par exemple, le droit de la communication. Ce droit de communication, quelquefois, est avec toute la famille d'origine, comme par exemple, on nous dit dans les rapports de Danemark, du Portugal, de l'Afrique du Sud, ou quelquefois, on restreint la communication avec les parents, parce qu'on croit que ce sont les parents d'origine qui peuvent troubler, disons, la relation avec la famille adoptive. Il y a d'autres pays où la loi ne donne pas une solution exprès, c'est le vide législatif. Et donc, il y a le débat de la doctrine, de la jurisprudence sur ce droit de communication. Mais, par exemple, en Turquie, la Cour de cassation, même s'il y a des silences de la loi, a dit que oui, que ça existe, ce droit de communication, parce que l'adoption ne doit supprimer les liaisons d'origine. Donc, on a ce droit de communication. Avec l'obligation d'assistance, ça arrive quelquefois que les parents adoptifs, c'est la majorité des lois, que les parents adoptifs sont principalement responsables de l'entretien de l'adopté. Mais on laisse aussi l'obligation des parents biologiques quand il y a besoin. En Belgique, par exemple, les parents biologiques ont un devoir secondaire du soutien à l'égard des enfants, malgré l'adoption. Ainsi, si les parents adoptifs ne sont pas en mesure de souvenir aux besoins de l'enfant, et les parents biologiques doivent le faire, même si il a été adopté. En Turquie, avec l'obligation d'assistance, c'est la même chose qu'avec les droits de la communication, c'est-à-dire la loi ne règle pas cette question. Et donc, ils ont le même débat pour l'obligation des parents. Mais c'est sûr, en Turquie, que ce sont les enfants, quand ils sont adultes, obligés à assister aux parents adoptifs et aux parents biologiques. Avec les droits de succession, il y a aussi, il n'y a pas uniformité dans les pays, donc on a lu les différents rapports. Par exemple, en Turquie, les parents adoptifs ne succèdent pas à l'enfant adopté, tandis qu'au Vietnam, les parents adoptifs et les enfants adoptifs se succèdent réciproquement. Il y a d'autres pays, comme par exemple le Québec, où la coutume des groupes originaires a donné lieu à la reconnaissance d'une adoption qui correspond à la coutume de ce groupe d'origine. Et ça, c'est que le Québec, comme il y a beaucoup d'autres pays, et comme on a dit dans les panneaux antérieurs, il y a ces reconnaissances du pluralisme juridique. Et donc, pour cette adoption coutumière qui reconnaît le Québec, l'adoption est effectuée pas pour le gouvernement étatique et selon les lois de l'État, mais par l'autorité compétente désignée pour la communauté. Et une fois que cette autorité a accepté l'adoption, on délivre un certificat d'adoption coutumière autochtone, et c'est ce certificat qui va dire quels sont les effets que cette adoption a. Le certificat pour indiquer les droits et les obligations qui demeurent pour chacun. Aussi, au Québec, il n'y a pas seulement l'adoption coutumière, mais de cette coutume, on a pris aussi ce qu'on appelle la tutelle supplétive. La tutelle supplétive permet au père ou à la mère de désigner une personne qui va exercer les rôles de tuteur et de titulaire de l'autorité parentale. Maintenant, on va voir le troisième problème, que c'était de la multiplicité de la parentalité dans le cas des trois parents. Qu'est-ce que ça veut dire ça, des trois parents? Bon, on a donné cette signification à cette expression trois parents. Ce n'est pas que l'expression trois parents, ça veut dire toujours la même chose, mais pour savoir de quelle chose on est en train de parler. Donc, les concepts qu'on a donné de cette expression trois parents, c'est que la technologie médicale, c'est cette technique médicale dite à trois parents, utilise donc le matériel génétique de deux femelles et d'une mâle au lieu d'une seule femelle et d'une seule mâle. Et donc, en règle générale, le ADN d'une femelle est utilisé pour corriger le ADN d'une autre femelle afin d'éliminer les mutations génétiques qui causent de graves maladies héréditaires. Donc, dans ce cas-là, quand, à l'aide de la technique, on a eu un enfant qui est le père, qui est la mère, ça c'est le problème. Donc, la règle, c'est que la plupart des rapporteurs nationaux déclarent que la loi de leur pays ne prévoit pas les enfants de trois parents et que leur juridiction ne permet pas une telle manipulation génétique. Donc, si ça c'est la prohibition, disons, qu'est-ce que ça arrive quand, nonobstant la prohibition, ça arrive dans la réalité? Donc, par exemple, en Belgique, en Grèce, en Québec, les règles ordinaires relatives à la détermination de la filiation parentale est à l'acquisition du statut juridique des parents et s'appliquerait à un enfant de trois parents si un tel enfant est né. Par conséquent, l'enfant n'aura pas trois parents légaux, mais deux, parce qu'il y a cette règle binaire, disons, on ne peut pas avoir trois parents. Donc, nonobstant qu'on a utilisé cette pratique médicale, on aura deux parents et pas trois parents. Les personnes qui souhaitent avoir l'enfant seraient les parents légaux de l'enfant et les donneurs de tout matériel génétique ne sera pas également lié à l'enfant. Parce que c'est ce qu'on appelle la volonté je ne sais pas comment on dit, en espagnol on dit la volonté procréationnelle, c'est-à-dire ceux qui ont la volonté d'être pères, qui seront les pères, mais seulement deux. Donc, il y a aussi, selon les rapporteurs, certaines solutions particulières. Par exemple, en Australie, on envisage la viabilité juridique de l'autorisation des dons de mitochondries, mais à l'heure actuelle, il n'est pas légalement reconnu. Et en Turquie, on nous a dit que la technologie trois parents n'est pas réglementée, mais certaines cliniques de fécondation in vitro offrent la transplantation mitochondriale. Et il semble que c'est illégal, Donc le législateur sûrement va interdire explicitement la technique à trois parents. En Afrique du Sud, il n'est pas certain que cet offert soit interdit. Et donc, nonobstant ça, l'enfant va avoir seulement deux parents. La loi sur l'enfance permet à plus d'une personne d'avoir les mêmes responsabilités et droits parentaux à l'égard du même enfant. Mais les articles de la loi ne font pas référence à trois parents. Ils se réfèrent à une mère biologique, à un père, à une personne mariée qui est artificiellement fécondée avec son conjoint. Et donc, il n'y a pas l'expression de trois, sinon seulement de deux, c'est le binarisme. Un parent exclut toute personne qui n'est pas biologiquement liée à un enfant en raison seulement d'être un donneur. Donc, j'essayais de vous montrer très vite avec l'aide d'un PowerPoint pour être, je ne sais pas, il me semble que ça va vous aider à connaître cette particularité. Sûrement, le point sur l'adoption est plus réglé par la loi, tandis que ce problème, disons, qui vient de l'évolution scientifique, la loi vient toujours derrière et on n'a pas de solution dans les lois. Merci.
Thank you, Aida, and thank you, Jackie, for this very detailed and rich overview of various family systems regarding family forms and family functions. We are looking forward to the final report. We are a little running out of time, so I take at least 5 minutes for discussion and questions. I want first to give the floor, the floor to the panel lists. Is there any question there? If not, I would like to ask Bruno if he has collected some questions.
Okay, so I have here 2 questions on behalf of the attendees. The first one would be, what role can comparative law play in the governance of cross-border adoptions? And the second one is the following. La Manif pour tous in France and similar movements worldwide have shown that there is a great resistance among conservative sectors of global society in relation to emerging family forms. How can comparative law contribute to the administration of conflicts existing between the so-called traditional family and emerging family forms?
Who would like to start? Jackie?
I think let's give Aida the one about adoption.
Yes, let me see again the question. I will see is in the chat the question, Bruno?
So the question is here on my computer. I can read it again.
Yes, please.
Okay. What role can comparative law play in the governance of cross-border adoptions?
Okay. So, you know that cross-border adoption is a main question, because sometimes in some countries, for example, in my country, in Argentina, we don't accept foreign people that want to adopt children living in Argentina. So it's something that this is the general politics in Argentina. Don't accept foreign people adopting children in Argentina. And they say, well, we don't help Argentine people that want to adopt children living in another countries. I don't agree with this general politics that my country have well, since, I don't know, at least 40 years. But this is an historical reason, disons. Je vais continuer en français. Donc, on a eu le problème de la disparition des personnes ici en Argentine. Et donc, on a eu ce problème. En général, on est contre l'adoption de personnes qui viennent de l'étranger, etc. Et c'est une règle qu'on a eue il y a longtemps dans le code. Mais, comme vous pouvez voir, ce problème, ce n'est pas le problème d'autres pays où, en général, on accepte l'adoption des personnes qui viennent d'autres pays. Mais il y a aussi une tendance générale qui vient des droits humains d'essayer de ne pas adopter une personne qui vient d'une culture absolument différente pour l'amener à un pays où les cultures sont absolument différentes. Donc, quelle est l'aide de droit comparé à ces points? Bon, à mon avis, les droits comparés doivent être une grande aide. Mais l'aide vient de que dans presque tout le pays, le point central, c'est l'intérieur supérieur de l'enfant. Et donc, accepter ou pas cette adoption qu'on peut appeler transfrontalière, ça doit dépendre pas des règles fermées comme les nôtres en Argentine, mais ça doit dépendre de l'intérêt de l'enfant. Peut-être à l'intérieur d'un pays, comme chez moi, on ne trouve pas des personnes où les personnes, normalement, on veut adopter des enfants qui viennent de naître, etc., sains, blancs, tout ça. Mais peut-être on peut trouver des personnes étrangères qui, enfin, vont amener cet enfant dans un pays que peut-être la culture est absolument différente, mais que c'est dans ce pays où cet enfant va trouver une famille qui les protège, etc. Et donc, à mon avis, c'est le point central que tous les pays reconnaissent, que c'est déjà une règle de droit comparé. C'est l'intérêt supérieur de l'enfant qui vient des droits humains, qui nous va aider à donner une solution à ce problème qui est grave par tout le problème de la reconnaissance de la multiculturalité dont Laurence nous a parlé ce matin, mais qui, toujours, c'est le principe de la proportionnalité qui doit régler la situation. Je ne sais pas si j'ai répondu à la question.
Merci, Aida. This was a very clear answer to a very difficult question. I give the floor to Jackie.
I'll keep my answer brief. The comparative law aspect in the context of family law and emerging families should, in my view, never be prescriptive. Family is such an intimate part of a society's being that I don't think that one can ever use comparative law to try and impose one system and one type of recognition for families on another country or another jurisdiction. But the value of comparative law is an educative one, I think. It can show other people and other countries that there are various possibilities. There are options that for recognizing or not recognizing particular families that are all acceptable. I think the main purpose of comparative law in respect of defining or defining family should be an accommodating one and not a prescriptive one. That what the message should be that it can be accommodated, but we're not going to prescribe what one system, a Western system or an Eastern system or an African system considers to be an acceptable family will not be imposed on another country or another culture. Because I don't think it would amount to paper law if one ever tried to use comparative law to force one jurisdiction to accept families that that particular jurisdiction is not ready to accept, because it's so closely related to culture.
Thank you very much, Jackie. And this leads me to a question. Can you already lift the veil regarding your personal own view on multiple parenthood, which after having, well, compared various systems might emerge?
Most jurisdictions still depart from the two-parent mode, definitely. But specifically from you asking for my personal view, from a South African perspective, multiplicity of parents is perhaps not such a strange concept, because we are familiar in South Africa, in Africa and some other countries with polygamous marriages, and with a child actually being raised by many de facto parents. It has not yet progressed to the extent that there is full legal recognition of that, but on the ground it is happening, and it has been happening for a very long time. So coming from the African perspective, it might not be such a strange concept, but most jurisdictions still do not accept anything but the two-parent model. Even if it's two women or two men, that some of the jurisdictions are moving towards, but having more than two parents, most jurisdictions still hesitant about that.
Well, the law might provide an answer. The law should be there to further diversity, as Edwin Cameron said in the beginning. So probably the law can provide different family forms, and this is possible to regulate. However, of course, we need laws and parliaments to be included in this.
To be willing,
yes.
To be willing to do it.
Yes. Indeed. Is there any other question in the chat or Bruno?
No.
No, there is none.
Excusez-moi, je voudrais dire quelque chose à propos de la jurisprudence récente en Argentine sur la multiparentalité. Et donc, même si la loi parle de deux parents, etc., mais on commence à trouver dans la jurisprudence argentine, comme au Brésil, certains cas de multiparentalité acceptés par la loi, et, excusez, par le juge, Et on parle aussi, on a commencé à parler de droit de l'enfant à ne pas opter, à n'avoir pas l'obligation d'opter pour un parent ou l'autre. Et donc, c'est l'enfant, si l'enfant veut avoir deux pères, une mère, bon, on n'a pas le droit de l'imposer à un enfant de dire un ou l'autre. Et donc, on commence à accepter cette multiparentalité dans certains cas très intéressants que, bon, quand on ira à Pretoria l'année prochaine, on aura le temps de commenter cette décision très intéressante de la jurisprudence argentine. Voilà.
Thank you very much, Aida. Almost closing words of this session. I cannot add something more specific or valuable to this. Thank you very, very much. We're looking forward to next year. And this brings me to the next point in our agenda, and these are the closing words of the Secretary General. Please, Diego, take the floor.
Hello.
It's okay.
Okay, I'm very sorry. J'ai pris quelques notes, mais je pense que je ne vais pas mentionner toutes les questions que j'ai prises. Seulement, je vais faire quelques commentaires très généraux. Mais je voudrais tout d'abord demander à Alexandre, le secrétaire général adjoint de l'Académie, s'il y a encore quelque chose à dire.
Je crois que je vais écourter de mon côté aussi, et juste pour vous rappeler que effectivement toutes les informations importantes vous les trouverez sur le site de l'Académie, idc-iacl.org, et que donc nous avons le plaisir aujourd'hui de partager avec vous aussi un nouveau podcast. Il y aura une nouvelle publication et évidemment le plus important, toutes les informations pour le congrès qui aura lieu l'année prochaine. Voilà. Je pense que c'est tout et je vais m'en tenir à cela et je repasse la parole au secrétaire général.
Merci beaucoup. Bon, et je pense qu'on a eu un extrêmement riche discussion, présentation aujourd'hui de ce qui va être les congrès l'année prochaine. Je suis vraiment très content et je pense que tous les personnes qui travaillent à l'Académie normalement sont aussi très content de cette possibilité qu'on a eu aujourd'hui d'avoir un avant-goût de ce qu'on va rencontrer l'année prochaine. Et, we have started with inaugural lecture of a presentation of what will be next year, the inaugural lecture, with cases, with examples about the impact of comparative law in the promotion of diversity in a given society. And I take, among many others, I take at least one point stressed by Edwin Cameron when he answers the questions, answered a question by saying that constitutional courts must promote diversity and the rights of minorities. And she reminds us the role of constitutional courts in building, and I quote, a moral citizenship for excluded person or deemed to be excluded person. I think this really gives us the deep interest in follow this discussion next year. Concerning the first panel, also extremely rich, and this way in the presentation of the liberal state or liberal constitutions on the one side, and the tradition and the historical and legal ways on the other hand, and all the examples we saw. I put concretely a question related to the idea of militant democracy as somehow opposed to the promotion of plurality in some cases, and the difficult balance to get to those issues. And again, I think it's extremely interesting, and it is challenging for comparative lawyers how we can deal with this reality. The report mentioned during the presentations from Krzysztof and Laurence were really totally intriguing for me. That there's examples, for example, in Japan, and that is harsh to hear that they say, well, we have a liberal constitution, but the women, foreign people, and even Japanese people from foreign origin are in a daily basis discriminated. And as to the second panel, which is fresher because it was the last one, it's very interesting, this confrontation, I can say. So the fact that on the one side, in all matters related with adoption or parenthood, state parenthood, based on situation of adoption, there are well-established law, but the practice is not always in accommodation with that. But at least we have a particular situation with clear legal framework. And on the other hand, we have the situations in which the technology is providing every day with new situations, and the lawmakers and even the courts are running behind, trying to catch up the new situations, the new future in family. So the discussion, someone asked about the discussion between conservative views and modern views, is just a part of the discussion. The problem is how we can grant the access to justice and a legal standard situation, a legal acceptable situation for those people, in particular for children that are being born within families which are not really they are not really yet contemplated by the current legal system. So that is a fascinating field for comparative lawyers, and again, all this make me really very eager to be in Pretoria next year. And it is not a matter of advertising. And really, I think so. Let me say just 2 words about the other activities of the Academy, and in particular, the General Congress in 2022. The General Congress in 2022 will be held, as you know, in Asunción, Paraguay, in October, and in October 2022, of course. And we are going to publish the list of General Rapporteurs. It is almost finished now. I think next week, hopefully we will publish the list, and to invite the national committees to appoint the national rapporteurs. The topics for the next General Congress of 2022 is really incredible. All the hot topics are there, and we are trying to gather the appropriate person to deal with those topics. And I think we are doing a good job. It's very difficult, but with the help of the president, of course, and Bruno and Alexander, it is less hard. So thank you all of you to join us today. Thank you to the speakers. I liked a lot all the presentations, and thank you for all the attendees to be there supporting the work of the Academy, and you are always welcome, and we will be waiting for you in Pretoria in October 2021. Thank you very much to all of you. See you.